What's up, everybody? Welcome back into the episode of The Lawyer You Know. Day 8 for Donna Adelson was the last day of evidence in her trial as the defense has rested. The state seemingly does not have a rebuttal case. They may or may not want to do some kind of stipulation or something, which we'll talk about. But Donna Adelson is not going to testify, which is a surprise to me. We will talk about the circumstances surrounding that, if any issues happen that we're going to hear about potentially on appeal if she's convicted. There were so many legal arguments today that I found incredibly interesting. Some of them I felt like were completely the default of one side or the other. I also didn't love the demeanor of some of the lawyers and the judge even in certain things that happened today, but I can understand how we got here based on what's been happening in the entire trial. So we're going to talk a lot about the lawyering. We're going to talk a little bit about the judge's decisions. We are going to talk about everything that happened today in this case and what is going to happen the rest of this week, when we think there's going to be a verdict, what we think that verdict is going to be. We're going to run a poll for you guys to vote as to what you think the verdict is going to be on this case now that both sides have rested. Hit that like button. Let's get to it. All right, so I was going to play this to start today, but I am actually not going to. I will just explain it to you instead, what happened, in case any of you did not watch in court. At the beginning of the day, there was an issue with a potential defense witness, which this is a real issue. This happens to defendants, and it sucks, and it's annoying, and it's part of the things that are very difficult and things that, make it seem like the process is sometimes unfair. But also this goes to, why are you waiting until now to flesh this out? Why are you looking this into now? Are they really prepared? Are they handling this case appropriately? From my perspective, it really was not a good look for anybody, but it was brought to their attention, and maybe that's why it didn't come out till now, because they didn't know about it, that somebody that worked at the jail could potentially have some information that could be helpful to the defense. The defense wanted to talk to her, and they say she was instructed not to talk to them because it could be bad for her career. The judge is like, okay, we bring somebody in from the jail. He says, no, that's not what I thought happened. What I thought happened was, she said the defense wants to talk to me. Do I have to talk to them? I talked to our general counsel. I told her she doesn't have to talk to them unless they subpoena her, and they haven't subpoenaed her. And the defense is like, well, we also heard now she's on leave, so we're not even able to subpoena her. And at the end of the day, the judge is like, well, do you want to call this person as a witness? And they said, we don't know, because we don't know what she's going to say. And that is one of the difficult parts about being a defense attorney versus a prosecutor, when you can really control these witnesses and people want to help you. They want to be on your team, right? But usually they don't want to be on the defense team or help the defense. And that's what happened. And that could be an issue, but we don't even know what she was going to say. So not something I really think is going to be an appellate issue. Totally understand where the judge is coming from. Agree with the judge's decision there. Okay. Next up, we have this witness that's on the stand. Kristin Adamson, something like that. She is Wendy's family law attorney. She testified in other cases within this conspiracy. Wendi has waived attorney-client privilege for her to be able to talk about these things. And she wasn't even Wendy's family law attorney throughout the entirety of the case. We'll talk about why. She talks about how divorces work in Florida. And today was a crash course in family law in Florida. One I didn't care to get. And we'll talk about how relevant it is to providing and presenting a defense for Donna Adelson. I'll just say this off the top. If your strategy is, this divorce case wasn't that contentious, therefore Donna Adelson didn't have a motive, I don't think that's very compelling. We've heard about the divorce case. We've heard about the conversations that were had. We heard about the name calling. We heard about the threats that Donna made of how she was going to go at Dan Markel. And we've heard some of the things Dan Markel has said and done, accusing people of fraud, including Wendi, Donna's child, her daughter, accusing her of fraud, trying to maybe get her thrown in jail, lose her bar card. All of those things are motive enough to do something horrible. But their defense and their theory was it wasn't that contentious. This is a totally normal divorce case. It's not unusual to seek relocation, especially in Tallahassee. She explains why. Very often, spouses' parents are involved. Whether somebody's 20 or 40, they're still your baby. Sometimes they even sit in at mediation. Now, here's one thing, again, that again is a little bit of a microcosm of the problem with this defense, is This attorney, who's been doing this for 37 years, said that relocation is about 50-50. Then when she was asked how many times she was able to get a judge to order relocation in 37 years, she said once. She's been able to, negotiate it a few times, and the burden has changed. You used to have to prove that it was detrimental to not relocate, and there would have to be some kind of abuse or some horrible things going on in that location in order to force them to move. But she says it's 50-50 unless I misunderstood her saying that, and she's only gotten it done once. So is it common? It seems like she knew they were going to lose and that it was kind of a losing argument. They go through, again, how family law cases work, how Wendi lost the relocation. She agreed to a denial. They worked through visitation. Wendi was calm, understood exactly how all this works, and she's a lawyer, but she was disappointed. They talked about how the fact that it's not that unusual to offer money in divorce cases for relocation, or if you give more money for this, maybe they'll give you more visitation. So the $1 million bribe that was talked about by the Adelsons, maybe this is a reason for it potentially. And so they discussed that with multiple witnesses, how that's not abnormal. And I tend to agree with that. I don't think that is abnormal. But when you're talking about potentially a hit and making jokes, hiring a hitman and how expensive it would be and how much money you're willing to pay or throw at Dan Markel to bribe him, it would maybe make sense that you would also pay money to somebody else to do something for you. And that's, I think, what the state's trying to line it up. They're not trying to say that, offering money in a divorce case is wrong. That's not what they're trying to say at all. Then they talk about, how much it costs, $30,000 in fees. And it's always funny to hear lawyers, myself included, talk about fees to your average person, right? Your average person probably thinks lawyers are overpaid. Maybe some people think doctors are overpaid. I think people think, athletes are overpaid. Everybody's overpaid, right? And that's how most people look at other people. And from my perspective, it's like the fees were only $30,000. He only owed $80,000 more dollars. They were trying to downplay all of that to try and explain how this was not a big case. This was not a contentious case. This was not a hard case. It was only $30,000 in fees. That was the point of bringing that up. Dan was supposed to pay Wendi $120,000 and then the attorney's fees of $10,000. He made one payment of $50,000. So he still owed her $70, Wendi $70, and this lawyer $10. So that's why they were trying to, get Dan to pay that money. And that's why the litigation continued after they had all settled everything and resolved, because another big point here was, this divorce was over. They had settled everything. Everything had resolved. Chris K said, Peter, I know you have said in the past, lawyers make terrible witnesses. Do you think it is because they try to out-lawyer the other lawyer? As a side note, $80,000 is a lot of money, even to rich people. Ain't nobody wants to pay $80,000 they don't have to pay. If you don't think you have to pay it, I don't want to pay the $80,000. Give me a break. Nobody wants to. I agree with you 100% there. Number two, I don't know that this witness was overly difficult as a lawyer, but hold that thought for a future witness who's also a lawyer. Wendi testified the divorce was contentious. Jen, this defense went completely over my head. I have to be completely honest. I did not see this defense coming. And you can go back to me talking about how it's such an obvious fact in this case that it was a contentious divorce. And frankly, more child custody than divorce. Because again, with two lawyers involved, I don't know, a couple $100,000 in dispute is not a lot of these divorce cases that are really contentious are millions and millions of dollars and, prenups and who's getting what and whatever. This was more about the kids. That was the really contentious part. Money's always going to be part of it. But it's wild to me to think that they were ever going to argue this was not a contentious divorce. PMD, can a witness politely refuse to testify? No, because they're politely served with a subpoena and they can be held in contempt and thrown in jail if they don't come testify. But it's a great question. If Donna isn't convicted, Ted, I'll be shocked. Not much of a case from the defense, in my opinion. We're going to talk about that more later. Nikki, I couldn't tell if she wanted to testify or if she was feeling pressured. Her hesitation made it unclear which side she leaned. What's your take? Well, Nikki, we are going to dive deep into that. And that's one of the reasons I didn't play the first clip of the day. I really want to take some time to talk about what happened with some of the legal arguments today. Sandra, thank you for gifting 5 Lawyer memberships. All right, let's take a look at our first clip here at some of the direct and some of the cross of this witness.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't even after the even afterwards. I didn't. They were fine. I had no issues with them. But I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
They were very lovely people. They were not involved. Another thing that came out in direct, Donna did not write any of these motions. I wrote them myself. I'm not going to have the mom of one of my, even though this client is a lawyer, I think she said at some point I represent a lot of lawyers and judges, but Donna was not that involved. Although it's not that weird if parents are involved, which I understand all of that. I actually think that was a good question for her. I would have focused more on like, yeah, Donna wasn't that involved from your perspective. Now we all know Donna was involved as far as Wendi knows. And we know Donna's mindset is what's important. What is the relevance as to whether or not the lawyer knew Donna was involved? Donna not writing the legal motions in this case is completely irrelevant to motive and the actual criminal case we're talking about. It was very clear. She cared. It was incredibly important to her. She was willing to spend $1 million on it and maybe more if the jury ends up finding that. She was very involved. This was a big part of her life. To act like that wasn't the case because the lawyer didn't know is starting to wade into the water of, and this is why sometimes defendants do not put forth a case. You don't want the jury to think you're trying to trick them or that this is some kind of smoke and mirrors. You don't want them to say, this is actually my left hand. I know it looks like my right hand. I know I'm writing with it and throwing with it and I'm right hand dominant, but this is actually my left hand. You don't want to do that to a jury. You don't want to be condescending to the jury. You don't want to try to trick the jury. And sometimes it can wade into that water to act like, Donna didn't care. This wasn't a contentious divorce. They were looking at houses up in Tallahassee. They were going to buy a vacation house in Tallahassee. This was no problemo for Donna and Harvey Adelson. That to me was not the move, but that's what they went with.
And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing or were they out in the hallway?
I believe they were in the hallway. I don't believe
because they were prospective witnesses. Again, I get it, and that point's good for you, but they were out in the hallway because they might have been called as witnesses. Now, I don't want to make a joke because this lawyer seems like a really nice guy. Okay, really, really nice guy. If I were not holding back, I might make a joke about lawyers knowing about the rule of sequestration in how it regards to Donna and Harvey in this family law trial or hearing.
they came in.
Just a moment, Your Honor.
All right. So that was the end of direct, and now we're going to get the beginning of cross.
Morning. Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendy's filings and having Wendi copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings? How about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendi to put in her filings in Wendy's voice?
Not that I'm aware of.
Okay. Did Wendi, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client, in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendi sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendi.
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied.
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that
Well,
time.
I'm always hopeful, but
Right.
And I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes,
Okay. Even given your best guidance?
yes.
Okay. That's not an uncommon thing.
no, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right. And at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
You know, I've been trying to think about that. I think that that's probably why I had them sit outside, is because they
Right.
could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until
Right.
you were done calling witnesses.
Correct. So that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why
most
they're in the
likely.
hallway.
Okay. Not because they didn't care.
I really like this lawyer's demeanor. I liked it better at times on cross than Georgia Kappelman. I liked how that was a brutal pause for me. I apologize for that. But I like how she was very direct in getting her points. And it's like very obvious, like that's why they were out in the hallway.
Or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. Came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
I don't like to lose either. So there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, I'll also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
Okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean, it was 13 years ago, I think I talked to all of them and kind of told them what happened and what was going on. And, I didn't agree with the judge, but this is the judge and they get to make the decisions. And I think that Wendi went and talked to her parents without me and then came back and said, okay, we're good. We can go into court and we can stipulate.
Okay.
Which is what I had suggested.
Sorry, if there.
So it was after she talked to her parents is kind of what they said. But regardless, you get the point. Everybody was calm, not a big deal. This was not a contentious divorce. This was totally normal, totally average family law case. And then she starts getting into it. She's like, well, have you had other cases where somebody died at the end, either at the hand of somebody else or their own? And she's like, yeah, I have had those cases, really sad. She's like, yeah, like this case. She's like, yeah. She's like, but it wasn't contentious. That's how this lawyer ended the cross. But it wasn't contentious. It's like, come on. Let's be honest, okay? Call a spade a spade. This was a contentious divorce. Doesn't mean that Donna Adelson is guilty, but when you start pitching that type of stuff to the jurors, I think you can swing and miss pretty severely. And she also mentioned, which I thought this was kind of crazy to hear this name, Jimmy Judkins, which I've heard that name in the past, that's who let her know Dan Markel died. And he was like good buddies with my dad, still is good buddies with my dad. I think law school classmates of my dad. I just asked my mom and that's what she said. And I was like, that's crazy that he was mentioned in his trial as well. Chris said, Peter, sorry, I was speaking about it. The family law expert, especially when she danced around the question about $80,000, the prosecutor asked. Oh, okay. Hey, Peter, longtime listener, first time super chat. Thoughts on the alleged gallery disruptions over his right shoulder is where Markels are sitting. Ever dealt with this in one of your trials? Yes, in my trials, though, there are usually less people there. So the person that is, yelling or doing something wild like that, it's easier to point them out than it probably is in this case. And from my perspective, I think the judge handled it appropriately. He's like, it's a public trial, so there's not a ton I can do. But if you can point out to the person who it was, we'll toss them. We'll toss them. And they should be tossed if they're going to be doing things like that. Peter, why wasn't Charlie called by either side? The short answer is neither side felt like he could help them. And I don't disagree. I don't really disagree. Kimber, Wendi had to waive attorney-client privilege. Yes, she did waive. I believe this witness testified she did waive attorney-client privilege. I know Donna Adelson waived attorney-client privilege for another lawyer. So many lawyers took the stand today. People ask me how I can be a criminal defense attorney. I want to know who in the world wants to be a divorce attorney. Gnarly work. Yeah. I had multiple attorneys who watch this YouTube channel and talk to me about these cases sometimes, and all of them said the same thing. Never would I ever want to do this type of work, and I get it. It's tough. In my opinion, the elements of first degree weren't proven. So we are going to do, Kelsey, remind me to do some polls as we go throughout the video today. There was also some discussion about Danny Markel claiming that this lawyer committed fraud, as well as Wendi. And on redirect, they were like, did you care about Dan Markel saying you committed fraud? Is that why you're here testifying? Because she did say something like, it wasn't that contentious. I do think Dan got mad at some point in the case and kind of said Dan was the one that was more contentious or angry about it than the Adelsons, which I thought was kind of an interesting move. And then that was the end of this first witness. And before we get to the second witness, let's pause for my favorite gummy greens now. Little ad here. I've really become a big proponent of gut health, energy, and focus. You don't even realize what a big difference it makes until you get your gut where it needs to be. A huge part of gut health is proper vitamins and minerals, greens, and prebiotics. One of the most annoying things can be taking powder or pills for so many different things. So that's why I love today's sponsor, Gruns. By far the easiest and most fun greens I've ever tried because I love gummies. And that's exactly what Gruns is. They're gummies full of minerals and vitamins. Each daily snack pack has 8 gummies. Sometimes I actually wish there were more because it's just kind of fun. I like gummies and I like the taste. And they're so quick and easy to make part of your routine. And it's also kind of cool how gummies are actually more absorbable than pills or powder. You can take these gummies in the morning or bring a pack with you wherever you want to go and wherever you want to take them. It's so convenient and easy. And I can't overstate enough how nice it is to take a gummy vitamin that actually tastes great, is more absorbable, and easy and convenient. So click my link in the description to get up to 52% off. So now we're going to jump to the first legal argument of the day. And these are the problems that compound if you are the defense team. When you make these kinds of mistakes, and I don't disagree with their argument. I actually agree with their argument. But they think the state stipulated something the state very clearly did not stipulate to. And that creates issues like this, where you don't ever get a final answer. You let an expert witness sit in and listen to that entire witness that we just watched testimony, and now she's going to come testify about it. And the state's like, we object because we never stipulated, and she just violated the rule of sequestration. The defense violated it for a second time. So let's listen to some of the argument, and then we will discuss what I agree with and don't agree with here that happened during these arguments.
Has anyone reviewed the transcript at this point?
Yes, sir.
Please make your argument.
I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts in reference to lay witnesses.
It's very common for experts to be able to sit in and listen to expert testimony. The prosecutor's like, that's what I'm agreeing to. The defense attorney's like, I very specifically said this expert witness's name to sit in during this witness's. It's like, okay, that's what you said, but that was never agreed to by the state.
We specifically said Linda Bailey would like to be able to observe Kristin Adamson's testimony when she testifies. And then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Y, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what's being discussed now. Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristin Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything about an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
It's definitely a violation of the rule. Definitely. No doubt about it. It's a violation. But the judge can't strike this witness. The rights of the defendant to have a fair trial are paramount. They're more important than basically anything else. And I really think if I was the defense, they didn't do this. They continued to argue. They called the witness up to the stand. They asked, did listening to her testimony change anything about your testimony? She says no. And so they continue to argue that there was no rule violation, or if there was, there's no prejudice, which is a winning argument as well. But the argument that she should be able to sit in here and listen to the testimony that she's about to be an expert on is a very valid legal argument. And I think the judge should have granted that. Even if the state objected, that's why we have a judge. If the lawyers don't agree, the judge makes the decision. But you don't just do it without letting the judge decide. And that was the really, really tough look here for the defense. Lauren said, were the defense attorney / experts characterizations of Dan's filings accurate? He knew he wouldn't win, but wanted to hurt Wendi, so he filed anyway. We'll talk through some of these, and I have a lot of thoughts on this. We're jumping ahead a little bit. Sometimes people absolutely file motions like that, especially in divorce proceeding cases. And I think some of them he probably knew were dead bang losers. Some of them were definitely more verbose than they needed to be. I think that was one of the words used, but I would not say that that's true with all of his filings or even most of his filings. Amy, hey, Peter, saw your video with your dad. Now I know where you get your handsome good looks from. Solid genes. Thank you, Amy. Do you think the defense is hurting themselves by these continued efforts of bashing Dan Markel? I failed to find the relevance in this testimony. They are, here's where I think that I agree with you, and we'll talk about it more when we get to the next witness. I think if I had to try to find the angle that they think is working with this argument that, you know, Dan Markel was nasty and was doing these things on purpose and writing these like law review articles, taking shots at his filings after they've spent the entire trial saying how great he was, what a brilliant guy he was, how nice he was, how sad it is that his kids no longer have a father, like all of these things they've been trying to go one way. Now they're switching, which again, being inconsistent, you can do that. Not a good look in this sense, number one. Number two, it has no relevance, but to maybe make the jury think, well, if they're admitting Dan was being a jerk, does that give Donna Adelson another reason to end his life? Because he was being a jerk to Wendi, trying to take her down, take her livelihood away? I don't know why you would try to make that argument. I don't get it. We're going to jump ahead a little bit here.
This topic to make sure we did not end up in this point in place.
He's like, I've already warned you about the rule of sequestration.
Thought we adequately addressed it last week during the sidebar.
Ms. Cappelman, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance, and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy. But
For a 2-second witness. She didn't ask for any exclusion for the witness that was on the stand for 2 seconds as a realtor that had nothing really to say, but their individual singular law expert, which I don't think she was that great anyway. Now they want to exclude the expert that they call. It's just never going to happen. Okay. This is one of those things where I know a lot of people online were like, oh yes, he screwed up again. They're going to strike this witness. The rules are the rules. You really shouldn't do this. But it's like, it's just never going to happen in reality. It's one of those things like you could accuse Dan Markel of being like, I'm going to try it, even though it might be a loser. Same thing, protecting the record. I would not have personally done this if I was the prosecutor, because if the judge would have granted this, I think it's a major appellate issue. And I don't think this witness helped them that much. I would have just been like, judge, for the record, we get it. We would just ask for an instruction to the jury or something like that, which the judge does end up doing. I think the risk of the real Donna coming out was too great to have her testify. That prosecutor would have taken her apart. I have a lot of thoughts on this. We will get there. PMD, new strategy, implode under mounting evidence. I wouldn't call that much of a strategy, PMD. Jacqueline, I've been diagnosed with a terminal illness. Hospice came by today. I don't know how long I have. I am going to need to cancel my membership. Oh man, I'm so sorry to hear that, Jacqueline. Pumped that you're here hanging out with us. Hopefully you'll get to hang out with us for a lot longer. Hopefully there's some kind of miraculous recovery. I'm so sorry to hear this.
push the defense to not let it happen again, and now it's happened again. So, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Cappelman, the court is bound by the rulings of the Supreme Court and the appellate courts. We can make it up on the fly. Clearly, this has happened twice.
He's like, listen, I'm bound by the rules. I mean, I agree with you. I'm not happy about it either.
Exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Viewing Earhart's exclusion of the witness Court may
Speaking of law school professors, Earhart, the evidence book, who literally wrote the book on evidence here, is also a professor at Florida State, helped me with all my mock trials, coming up with what objections to make and arguments to make when I did my competitions, which was awesome. Talked to him a lot more than Dan Markel. Dan Markel, I just listened to speak basically as I'm in an audience and he's giving a seminar. And I did talk to him after for like 2 seconds, but wasn't like buddies with him. Earhart, I would like go to his office. He was awesome. He was amazing.
exclude witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
Which is why I believe
And that's the argument. They take a break. The judge is like, I'm going to have to consider this. They put her on the stand. She said, it wasn't that big of a change or nothing changed. I'm going to jump to when the judge comes back so we can hear the judge's ruling and what he's going to do about this.
concerning this issue of the testimony of Wendi Bailey, court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of a witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412-72-332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter.
And that's a problem for the defense, because while it doesn't really matter and they're just going to testify, they're going to hear the defense violated this rule twice. What do you think the jury is going to think about that? Kathleen said, have you ever seen a defense so unprepared? Yes, I've seen much, 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 much worse. And I mean, we've handled some criminal appeals for ineffective assistance of counsel where they didn't object a single time in the entire trial. Called zero witnesses, did literally nothing when someone's life was on the line. So I've seen worse. Brianna, how do you spell Earhart? It's Charles is his first name, E-H-R. I don't know how to spell it. Starts with an E. Charles is his first name, Chuck Earhart. BB, I heard you in my head when watching today on this issue of striking the witness. Would have hated that, as could be appeal issue if convicted. In my opinion, this witness would not hurt the state's case. Yeah. I mean, you guys you're picking this stuff up, right? And as we keep going, that's what I'm saying. Like, you guys will be really good jurors because you understand the process more. You'll be able to cut through the BS and just judge the facts, be impartial, know how you're supposed to come in there, know about the presumption of innocence beyond a reasonable doubt. All really important stuff to know as jurors that most jurors don't know. Okay, next witness is that family law expert, Ms. Bailey, who seemed to be best friends with the prior witness. She would say, oh yeah, as she said, or I agree with her. And just as she explained, it was almost like bolstering of that prior witness. And to me, a lot of what she said was not even an expert opinion, but the judge allowed her to testify. I assume the state objected and they went through whether or not she actually is going to testify to this. I also had multiple, I'm not a family law lawyer. I had multiple family law lawyers, some who I know, some who I don't even know, reach out to me and say, she's dead wrong. That she overgeneralized way too much for what happens in family law cases. Generally, they are very contentious. And even ones that can go quickly can be very contentious. And that is absolutely not, she did not do a good job of explaining how family law works in the family law. So I'll leave that to them. That's what they said. They do go through all of her accolades, super lawyers, best lawyers, etc. And basically she said this was not a contentious divorce. So the second witness to come up and explain this was not a contentious divorce. This was not unusual. Let's hear just a little clip of her saying that and explaining that.
Official petition for dissolution of marriage was filed and when the final judgment of dissolution was entered.
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial. And
Immediately, and I'm not accusing anybody of anything, but that would make me think like, did the lawyer do everything they could to try to get relocated? You know, did they push hard enough? Is there any other motions they could have filed? I don't know. But it's like, you never want to hear your case went so fast and it was all done. If you really, really wanted something like Donna and Wendi seemed to really want between their emails going back and forth.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
no, to the contrary, it was settled amicably and everybody was moving on with their lives.
And quickly.
If this was true, because some of these motions filed, I mean, you had two lawyers. I would think 2 lawyers is usually more than average contention between them than, 2 people that aren't lawyers. But also you have to realize like they're only seeing cases that people hire lawyers because some cases you don't even need a lawyer, everything's already agreed to or whatever it may be. So, they're only seeing the higher level of contentious divorces, I guess you could say. I'm going to jump ahead to when she gets more into Donna's involvement.
I did review that deposition. Then there was
I believe Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No, we have parental involvement, as Ms. Adamson said. Often, sometimes it's employer.
As Miss Addison said, right? I mean, she said that multiple times. She's like, no, not a big deal to have parent involvement. And that makes sense, right? My case is I got family members involvement all the time as well. Not that big of a deal. But I don't usually have parents writing the kinds of things that Donna was writing. So to say that that was like normal Jewish grandma activity, again, to me, if I'm a juror, that's falling flat because it's not hitting with my common sense. It's not clocking with me.
Involvement, maybe they're very attached to their employer and they want to nurture them, or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers.
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you
Like on one hand, it's like, oh, that's nice. Donna Adelson loves her daughter. On another hand, it's like they do things for their babies they would never ordinarily do, or that their friends maybe could never see them doing. Right? I mean, there's 2 ways to look at that statement.
reviewed, did you see my client's use of the nickname Gibbers to just to refer to Mr. Markel?
And here we go. Here's another thing where I was just like, why didn't we leave this? Why are we bringing this back up?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's,
How would she know what a nickname means for people that she didn't even work for? Like, who told her that that's what that meant? Because this opened the door for the prosecutor, to me, to state facts not in evidence and to testify potentially inappropriately. But if she's going to say gibbers means this, the prosecutor says gibbers means something else, which nobody testified to. And I don't necessarily think was an appropriate question, except that this potentially opened the door to it.
motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers. So it appeared that he was drafting them, were very.
They just said, we never let our clients write our motions. No way. We're the lawyers. We got to sign our name to it. They're like, obviously Dan Markel was writing his own motions because he was a lawyer. It's like, okay. Like, do we know that? Because they are saying the same thing about you guys, right? They're just both pointing the finger at each other here. And it's like, believe us, not them. That's what it's kind of come down to.
Very wordy and full of hyperbole.
In that same vein, the lawyers that represented
By the way, some lawyers do that too, like in their own motions. She's like, a trial lawyer would never do that. It's like, I mean, I don't do that, but I have definitely seen it in some motions that I've read.
and have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because
And she was talking about how bad they were. Again, multiple shots taken at Dan Markel during her testimony. They talked again about not abnormal to offer money. Dan said Wendi and the lawyer committed fraud. Who's a very good friend of this lawyer. I think she said they went to law school together, maybe. But then they get to, this was also something I think was actually interesting, is more explanation about the grandma motion, which I think that the state couched a certain way that this is maybe the best part about this person's testimony is, and I think the prior lawyer said the same thing, where it's like they weren't actually trying to stop Donna from being able to spend time with the kids. There was the right of first refusal, and that was explained. If I don't have the clip here, I'll explain to you what that means. That I thought was the best little itty bitty thing that came out of this witness. And if you would have pared it down and would have been able to just get a couple points out, I think it would have been much better than how it kind of went.
Was there any indication that those claims were true?
no, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in this motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not.
Sorry. Okay, hold on. I was a little ahead.
So he mentioned that. I think it was his 8 of 10 points in that motion.
Was it in that pleading that he was asking for?
So they're talking about how important was this grandma thing? Where did he mention it? Did he even know if it was true? I thought this was the maybe the one good part of this presentation of this witness.
I think like the 8th point he made.
And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest. And there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in this motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not, but I would like Wendi to make it stop if it's true.
Did this motion, the March 26, 2014 motion that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe 0.45, and then he kind of tied in this grandparent thing on 0.8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school. So he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose?
All right. So we'll hear her explanation and then kind of you get the gist. And I thought, again, this was something that was enlightening. This is something I'm like, okay, so maybe the grandma motion wasn't as big of a deal as the state wanted it to be. And you start to pick apart and try to poke some holes, but it gets lost in a lot of the other things that was said.
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if my rule, or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing. And so you don't want them to never be able to spend the night with grandma or never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first.
So you get it. So you understand what they're going with there. K Luck, hi Peter. Could it work against the defense appeal that the judge is allowing the witnesses after the sequestration violation? Oh yeah, no appellate issue now. The judge is the sequestration appellate issue is gone. It was only there if you would have struck these witnesses. Can I help Jacqueline with her membership? If there is a way to do that, I am all for that. I don't know what control I have over that. It's a YouTube membership, so it's not like something that I control either side of the transaction. Lita, if the judge must allow the person to testify who sat in the gallery due to a fair defense, what is to keep others from sitting during testimonies? Is sequestration not that big of a deal? So this is a great question. And it's not that it's not a big deal, but in this scenario, you can understand the good faith basis the defense has. They specifically named this witness at sidebar. They misunderstood thinking the state said yes. That was wrong. Secondly, she's an expert. And if you were to just say, can a lay person violate the rule of sequestration? The judge would be like, no way, you can't do that. Like you can't do that purposely. The defense purposely let this witness sit in there, but she was an expert. So there was a totality of the circumstances situation. If they would just let every witness sit in there, the judge absolutely would strike them appropriately and it would not be an appellate issue. Thank you for that question. It was a very good one. And I don't always give it depends and clarification. So I appreciate when you guys dig in and ask the good questions. Jilly, Donna saw what Georgia did to the second lawyer and noped out of testifying so fast. I don't think that that's what made the decision, but I understand. And we're about to hear some of that in a second. I don't think I've ever witnessed two more unprepared lawyers during a trial and wondering if manipulations by Donna is affecting them. I have definitely seen worse. I will tell you that. Brittany, I could only half watch all day due to work, but it felt to me like the defense was desperately grasping at straws and just wasting everyone's time. It did feel like they felt like they had to put on a defense just to put on a defense. At the end, if I have time in the video, I kind of want to go through all the defense witnesses and be like, what was the main point? Like if I'm a juror, what was the main point of this witness, this witness, this witness, this witness? Why do you think Georgia went so strong after this witness, but not after Wendi? I missed the passion in the state case in chief. So I don't know the answer. Maybe she thought Wendi was a better witness than this. Maybe she wanted to make sure she stuck within what they gave her immunity for and didn't want to stretch it too far to give her immunity for anything she said outside of those bounds. But speaking of that cross, am I there yet? So they try to talk about a different case he brings all these binders as like a demonstrative and like, this is a contentious case. Look at all these binders and boxes. To me, it looked like nothing still for most of our trials, like those binders, like that's it. But he was like, I want to talk about this case, judge, to compare it. The judge is like, what's the relevance? Didn't really give a good explanation. The judge is like, yeah, no, we're not going to do that. We're not going to do that. So that was the appropriate ruling by the judge, even though it did cut against the defense. And again, she ended with the Markell divorce was simple, amicable, quick, easy, bada bing, no big deal. And Georgia Kappelman comes in swinging. So we're going to get to that. She starts out with like, why were you hired in this case? But we quickly get to the fireworks and we'll talk about my feeling about this cross. It was kind of like highs and lows to me.
There was no foundation for those asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases or give or take 100 on each side. And I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're
A great point by the prosecutor. It's like, who cares whether you think it was contentious?
somebody that has vast experience with.
Judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with.
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with
Ms.
that?
Kappelman, Ms. Bailey, wait for the question, wait for the answer.
I think she gets a little frustrated, right? I think she has really good points, but I think certain times the emotion is a little too high if I'm a juror. Plain Jane said, that's not true with first right of refusal. You're supposed to offer the other parent the time before a third party. I disagree that it's every single time. Like she said, you're allowed to do sleepovers with grandma. You're allowed to set up things where grandma can watch them. And if you happen to be out while they're hanging out with grandma or going to a friend's house, you don't have to offer to them, go to the other parent's house every single time. That's kind of how she explained it. That's my understanding. I'm not a family law lawyer. We don't need to debate it, but I understand if people want to disagree with kind of her explanation of it. Paige, thank you for gifting one Lawyer You Know membership.
Do not speak over each other.
Do you agree that a case as a lawyer might be routine, whereas to the parties it's the most important thing in the world?
We're going to think about that later when we talk about Donna Adelson testifying, but this is an amazing point. And I tell my clients this, when we talk about whether we're going to file a lawsuit or not, I'm like, it doesn't matter to me. It's my job. I do this every single day. A lawsuit's going to be very different for you in your life. Let me explain to you how it's going to affect your life. I'm going to show up here. I'm going to punch in. I'm going to start working, writing motions, making arguments, calling opposing counsel, whatever. Like, to me, it doesn't matter because it's just normal life, right? It's work for us. And I thought that was an amazing point by the prosecutor. And it's like, but it's not for Donna Adelson. So whether you think it's contentious or not, doesn't matter a lick. If this family thinks it's incredibly contentious, it's life or death to them.
To some degree, that's one reason I call Kristin, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done.
So all of that attorney's clients, it's no big deal for them. It doesn't get contentious because she's so calm and even-handed. I was like, what? It's like advertising for that other lawyer. It's like, well, because she's so calm, like, obviously it wasn't very contentious. It's like,
She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get a motion. If I get something, for example, that, although I've never had something similar to what Mr. Markell would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what you communicated to Wendi.
And when you communicate these
I just don't understand how this is appropriate for expert testimony either.
things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind.
That's what I would have, like, again, this is total nitpicking. Okay. I'm watching it for a second time, but like like these kind of things as a lawyer, you usually don't want to do that in front of a jury. It seems like you're exasperated. Now, here's the other thing. If the jury feels the same way as the prosecutor, it's over for the defense. So that's where it can kind of be a line where if you go over into this, like, I'm emotional now about this, and I'm trying to show you how emotional I am. And if the jury feels the same way, you're cooked as the defense team.
Mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think
Definitely being evasive and being a difficult witness.
I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is
He doesn't get the reference that the garbage stinks to us. I could never sit on a garbage truck. Garbage men do it and they're like, it's fine. It's no big deal. That's like lawyers with our cases, right? But for the client, it's a much bigger deal. It's a great analogy, but this witness is being evasive on purpose.
Might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question.
Again, I would like, if I watched tape back of myself doing that, I'd be like, I wish I would not have done that. You can't agree with it. Strike the question. It's like, it's a little too much for me. A little too much. She's awesome. I think she's a great prosecutor. That was a little too much for me personally. I know I'm getting ahead, but I didn't understand why Georgia asked these two comments to be, no. Come on, Bach. I don't want to, I'm save that. I got comments about that. How many jurors have been divorced? So in jury selection, multiple jurors said they've been divorced. Most of them said it was amicable. And I would think their definition of amicable, I think some of them said it took like a week to do their divorce, are going to look at this one and be like, no, this was not amicable. Susan C., thank you so much. 5 gifted lawyer, memberships.
You were asked.
There are other people saying, I loved it. So, hey, you go ahead. You tell me. You disagree. What did you think of it? What did you think of the emotion she showed here? And I want to say parts of this I thought were amazing. Like I thought she pinpointed some really great points on this cross. There were just a few moments I was just like, just dial it back a little bit.
Let me ask you this. Let's go on to something else. People,
Have anyone more committee after the
this is not shameful, is it?
I wanted to get to the $80,000. Not a lot of money. Show me the money. That's what it reminded me of.
Aren't these issues to make people upset?
potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal. It wouldn't be granted. It was buried in there. But the allegation is grandma is disparaging me to these kids and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
And that is so exactly inappropriate. Shouldn't say it, but she's right. That's the point. Whether or not this is pissing somebody off, you got to ask the person it's written about, not the lawyer handling the case.
It shouldn't have been. There was no proof.
It shouldn't have been. There's no proof. So somebody calls you a name. So here, let me pick somebody. Oh, you know what? I noticed this comment. So it's the perfect time because I like Ben. Ben, hey, it's Ben, the Karen Reed is guilty guy. Donna is guilty too, in my opinion. But can you explain why fleeing is a guilty act? If I was innocent and saw my son locked up, I knew I was next, I'd leave too. So Ben, you make a great point, and that's the argument the defense can make. But the reason it's allowed for the state to argue consciousness of guilt, that doesn't mean it is consciousness of guilt. The state can argue it's consciousness of guilt, same way a Google search. Doesn't mean you're guilty just because you Google search something, but they can argue that. So it's argument that is consciousness of guilt that you're leaving because you know you did it and you know you're cooked. That's what the state can argue. But the defense can argue exactly what you said. But let me just say, let's say I called Ben a nasty name here, okay, which I would never do to Ben, but I'm going to use him as an example. So Ben is a loser, right? Whatever you want to say about Ben. But it's clearly not true. I don't even know Ben. I've never met Ben. Do you think Ben could still get annoyed that I called him a loser? It's like, that's the whole point. It's like, just because, oh yeah, it has no legal basis. Like, if I could tell you how many times I told my client, oh, don't worry, we're going to win this motion. It's not a big deal, that they still weren't pissed off that it got filed. Come on. So Sleuthy, so here, I will push back against this. So again, in this case, I know how everybody thinks, but let's just say it's you. And it's you and your sister. And your sister's convicted in this conspiracy. And you're listed. And they talk about you throughout the whole trial. And you know it didn't happen. But it was enough to get her convicted. So you may be like, well, then if she got convicted, I know I'm going to get convicted. I got to get out of here because I know I didn't do it. That's what Ben is saying. And that is what you can try to argue. That's what you can try to argue as the defense, right? But that's why it's just one piece. One piece. Ben is smart, not a loser. I agree. Ben is smart, not a loser. That was using it as an analogy. Thank you, Ben, for subjecting yourself to that, even though you didn't actually do it. But I appreciate you, Ben. What the chart won't say. Thank you for gifting 10 Lawyer You Know memberships. Okay. I think the $80,000 is a lot of money is coming up here. I want to hear it.
Right?
Sure.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition.
That gave her the opportunity to say it again, and she's just testifying at this point. The facts, not evidence. I would have objected. There was no objection. But again, the argument would be they opened the door.
Definition of someone that speaks gibberish. Can we agree it's not a flattering term?
She even said like the whatever, I'm not going to repeat what she said gibberish means, but she said it. And then she said, or somebody speaking gibberish. Can we agree it's not a flattering term? So her question is, gibberish is not a flattering term. She didn't even really ask the question about what the meaning was. That is purely her testifying to facts, not in evidence. So the jury heard it. Objection, strike that answer. That absolutely should have been objected to.
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
Yeah, I think
$80,000 is a lot of money, Miss Bailey.
on that issue, he clearly had the asset. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Well, you sat in the courtroom.
Okay, so they go through whether or not you could potentially go to jail for being held in contempt, how unusual it is in these kinds of cases, yada, yada, yada. I'm not going to play it again. We've already heard how she categorizes some of Dan's filings and, takes some shots. The comparison case would have been shorter. And this was a great point. The prosecutor's like, well, that case, we saw all those binders. Was somebody's life taken in that case? No. Might have been shorter if they were, right? She's like, well, yes, if something happens to one of the parties, then it'll be shorter. It's like, exactly. More could have happened in this case, but it didn't, because Dan Markel's life was taken. That's a big deal. Let's just listen to the end of it. I like how she ended this.
And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
So that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
Yeah, I have a moment.
I mean, that's just such a great ending. That is such a good ending. And she just had to say clearly. She was like, clearly. I'm a few minutes behind, but thinking if any of those jurors had been through a divorce, they know better to think the divorce wasn't contentious. Most of the jurors that I heard during jury selection talk about it, which again was not all of them, none of them might be on the jury. There was a lot less contentious divorces than you may think. Nina, if I was guilty, I would totally confess to my attorney. What would you do in that case? Withdraw? No, we talk about options, right? We talk about options. We can't lie. We can't put fraud on the court or do something that's not true. We see if there's a deal to be worked out, or there's lots of options, even if you admit to doing something. Lawyer does not have to withdraw. But man, that was such a chef's kiss ending. Great job. Okay, the defense argument before lunch was about, somebody in the gallery making noises, things like that. Okay, then we get to, Donna's going to waive attorney-client privilege, but we get to the first argument about whether or not Donna is going to testify, which to me was one of the biggest points of today. And by the way, we are just getting here now, but it is past an hour. We got a little bit of time left because I want to really get into this. This is really important, but we're past an hour. We're into overtime. I like to usually have these recaps to be 1 hour. So hit that like button if you guys are going to stick around through some overtime. And Charlie has gifted 5 Lawyer memberships. Thank you so much, Charlie. And we are going to give these memberships in overtime. And we're going to put our first poll up. Kelsey just reminded me, since we're in overtime, first degree M right now. If you had to guess, guilty or not guilty for Donna Adelson, we're going to do all 3 counts: conspiracy, solicitation, and first degree M. Let's start with first degree M. Guilty or not guilty based on all the evidence you heard. And I will tell you my thoughts after we go with all 3 polls. All right. Yes, here are the polls. Don't worry, Kayla. Here we go. Kelsey's here to remind me. She did it. Okay, here we go. Let's talk about whether or not Donna Adelson's going to testify. I thought she would. They've said she would. They've indicated. They've made arguments that certainly make you feel like she would. I think they've built their entire defense around her, the jury having to believe her. taking the stand, feeling bad for her grandma. I would never do this. I didn't know what was going on. That's the best part of their defense is I had no clue what was going on. I don't know what he was using the money for. I gave Charlie cash all the time. I was doing what he said with Katie McBanawan. When I got the bump, Charlie told me somebody was extorting him. You got to say it. They got to believe you, right? That's the way I look at it. That's the way they've built this defense. I'm not a proponent for defendants to testify most of the time. I usually think they shouldn't. And I think she would have been absolutely destroyed on cross. Absolutely destroyed. But I feel like this defense is almost a nothing burger with how they set it up and what she ended up making, what decision she ended up making.
Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do.
What is that scope?
The information that we discussed
Oh, whoops.
after my son.
I guess this is happening. Maybe it happens right after this.
So the matters are inquired into that exceed the scope. At that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way? As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may judge, the issue is that
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any
I
sort.
love when judges do that. I had to do that in my last trial. Both lawyers were arguing. I was like, Judge, who's handling objections here during this witness? And I probably was more terse than I wanted to be, but the judge was like, yeah, we don't do that here. You got to pick one lawyer that's going to argue these. And the lawyer that was direct examining the witness was not the lawyer arguing objections. I was like, whatever, I don't even care. It was kind of funny.
Your Honor, what Ms. Fulford and I have discussed, so aside from that,
this was
So Fulford's going to handle these. Like, we only got 20 minutes to talk to her about it on the lunch break.
6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with.
That was one of the mistakes made by the defense. They're like, we need additional time. I would have just specifically said tomorrow morning, Judge, 8:30 will tell you. Because by the time they were done with their witnesses today, because they had 2 more after this, it was after 3 o'clock. And court's gone till 5, maybe 5:30. And I realize they've had time. I realize the judge is pushing them to do it. I get all that. But what's the prejudice? They did jury instructions for 2 hours today anyway. They were going to send the jury home to do it, whether she testified or not. You can do the jury instructions this afternoon, send her home. It's her Fifth Amendment right. Just like the prosecutor said, this is Donna Adelson's one trial. It might not be a big deal to the lawyers or the judges. It still is. But this is their one trial. It's a Fifth Amendment right. We really can't give her an hour and 45 minutes. Like, we can't waste an hour and 45 minutes of court time. I just totally disagree with the judge continuing to push. I think it is absolutely going to be an appellate issue if he continues to push. We'll see what he does at the end of the day.
Our client, so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there's been time pre-trial to prepare for this moment. There's been time during trial, and specifically we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed. So we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what is actually coming in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, The defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that.
So he gives them 5 additional minutes. And they want more time, I believe, after that. Let me see. Actually, we don't know what happens after that, but there's another colloquy later. I just want to hit some of the comments here on this. Candy said, Donna is guilty. Trial went pretty fast. What's next? As always, go Knowles. You guys tell me what's next. You guys tell me what's next. Will closings be longer than deliberations? 2 hours each side for closing. So it's possible. But cross would be limited on direct questions. Limited to the scope? Yeah, but if you say you didn't do it, that opens up all the evidence that you did do it. And the state can get into that evidence. All right, so here's how, this is the general sentiment of people online. And I'm just going to read some comments here. She's had years to know if she'd testify. No more witnesses after Peter. When this is happening right now, the defense still had 2 more witnesses. 2 more witnesses after this discussion right here. We're going to talk about them. She had plenty of time, though. Can they appeal her not testifying? She's had 11 years. She just had a 3-day weekend. We're not talking about, they were vague in what they asked for, okay? But they're not asking for 3 weeks. They're asking for the judges to give them till the next day, till the morning. This is an easy decision to me. It was not even a close call, and the judge continues to push her to testify. And I get it. Nobody in the public thinks she needs more time. She's had plenty of time, as if trials aren't living and breathing things. As if there aren't, jailhouse snitches saying one thing when the investigator said they were saying another. There's a witness potentially for them at the jail they want to talk to, and they're not able to because somebody tells her not to testify. The defense lawyers are dealing with a lot. Defense lawyers deal with a lot in every case, okay? I know nobody has any sympathy for them, and I understand that. I just think this was an easy call. Hour and 45 minutes. Let's just handle jury instructions. Come back, and at 8:30 on the dot, not 8:31, I'm holding you in contempt if you don't have an answer at 8:30. Give me your answer at 8:30, or even email me tonight by midnight with your decision, whatever, and we'll do the colloquy in the morning. They didn't ask for the morning. That's what I'm saying. They did not ask for the morning. They just asked for more time, which I think was a mistake by them. I would have asked for more money. I would ask for more money. They needed more money on this case. I would have asked specifically for the morning. A setup for appeal seems like you can't set it up for the appeal if the judge gives you more time, right? But now it's definitely an appellate issue. I think this is potentially the number one appellate issue. Was this a knowing and intelligent and voluntary waiver of her right to testify, of her right to remain silent? Not guilty on first, but maybe lesser second or manslaughter. Okay, let me get the poll here. 83% say guilty. 17% say not guilty. All right, now let's put up the poll for conspiracy. Conspiracy to commit M. Your thoughts on her ex-attorney clarifying that they spoke about the vacation before Charlie was found not guilty, not what the defense said at all. I agree. And that was the next witness, so let's jump into it now. Miss Descalzo or something like that was her lawyer at the time Charlie was being, prosecuted. They had a discussion about her traveling. She also, another big word that she used that I put in all caps in my notes, she assumed the prosecutor would tell her about a warrant before one was issued. And what was the discussion about if a warrant was issued? What would she do? The prosecutor never guaranteed that Donna could self-surrender. She was making serious threats on her own life. They thought it would be good and healthy for her to take a vacation. Not great for Donna. I thought this witness was not good for Donna. And they called her. Whose decision is it how someone surrenders on cross? Law enforcement. They can give a courtesy. They don't have to. Yes, that's obviously true. Harvey suggested a vacation. She didn't know if they were looking at non-extradition countries. She said absolutely circumstances can change. And if you threaten to flee, obviously that might not be good for you. She's like, I can't answer what law enforcement does. I know it would make the bond hearing more difficult if they got word of that. Not good for Donna. Redirect, she was not fleeing the jurisdiction. It was a vacation. She said that was my understanding. Non-extradition country absolutely does not mean there's no way they get extradited, especially if you're a U.S. citizen. I did think that was probably the best point they got across. Next witness was Sara Newhouse, the victim's advocate. And these were 2 quick witnesses, but this one I want to play a little bit for you because, again, I was like, uh-oh for Donna here. Let's take a listen to this witness.
What is marked for identification purposes, exhibit reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother.
It is.
When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markell had been shot?
Yes.
Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she...
She was shocked, and it appeared it was the first time she had heard about it. That's good for the defense.
Did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear it other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
That's great for the defense. And then he wants to put in that interview. And the prosecutor's like, well, no, I object to some things in that interview because there's some hearsay. And it specifically had to do with what Wendi Adelson said at the beginning of that. And the judge is like, you know what, you're right. Defense, can you clip that? Defense is like, yeah, we'll clip that. And then Georgia gets up for cross. And here's what she does. Which again, to me, like borderline unethical. Like you really should not ask this question that you know is inappropriate. Yet here it comes. All right, here it is.
And at this time, you may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know.
Correct.
Do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the
Literally exactly what she asked me removed. Now, the judge isn't happy that he made that comment in front of the jury. That's a speaking objection. He probably shouldn't have done that. But like, she should not have asked that question.
That's the hearsay, sustained.
No further questions.
So the judge sustains it and she sits down because she knew that was not appropriate. She's like, okay, whatever. I'm just going to sit down. I don't know that she knew that, but it seems like how quickly she sat down. She's like, okay, whatever. I got my point because the jury got to hear me say it.
Redirect.
Your Honor, strike question from Ms. Kappelman.
Members of the jury, you are to disregard the last question of the prosecutor to be struck from the record. You may step down. Will the witness...
And he strikes it, as he should. People are saying I don't get the Georgia Kappelman hate. Do you mean from me? Like, listen, no lawyer is perfect. If I watched myself do a trial, I'd be like, oh, you shouldn't have done that. Oh, that was bad. Oh, you did too far. You missed this. You missed that. This was good. That was bad. Like, I think she's great. Like, I feel like I've sung her praises throughout a lot of this trial. That doesn't mean I'm not going to disagree with something she does here or something she argues there. Same thing with this judge. I've loved this judge. I think he's been amazing. But I'm just going to call it like I see it, I guess. But why didn't she want the jury to hear it? I don't get it. She could, if she wanted to ask that question, she could have let the question in. She could have let the recording in. But she didn't. And that's the point. You can't have it both ways. I don't get it either. It doesn't make sense. Doesn't make sense. Okay. Now let's jump to the final argument here. This is what we're going to finish with today. It is a few minutes long. But we're going to finish with the discussion about Donna Adelson testifying. He says, state, are you going to do a rebuttal? And she's like, I don't think so, as long as they're not calling any other witnesses. So if they call Donna, they might have to put on rebuttal witnesses, and they want to keep all the leverage points they can possibly have. Like, be careful what you do here, Donna. Be careful what you do. Lauren said, can the defense come back tomorrow and say Donna wants to testify? They could try, and the judge might let them reopen their case because they just rested. I think if I was the judge, I'd let her. And you can call me that I care too much about defendants' right to a fair trial. I'd let her. And guess what? I think it might help the state if she testifies. But I would let her if she tried to do that in the morning. I really would. Tar Girl. He gave her the last night to think about it over and was supposed to have an answer this morning. This defense was just doing it to keep pushing the judge. Tar Girl, you might be a lawyer. I don't know. I've tried a lot of cases. I've had a lot of cases where criminal defendants may or may not testify. I know how this works. Things come in, it changes, it's living and breathing. It's a spur of the moment decision. If you want time to sleep on it, especially like I already said, elderly client, morning is usually better than the afternoon. Like, I've had this decision to make with clients before. And I will just tell you, it is not at all unreasonable to ask for the end of one more day. I don't care if the trial's been 45 days and you could have been considering it for 45 days. If you asked for an hour and a half at the end of the day to end early so you could discuss it, I think every single judge should give it to you in every single circumstance. I stand behind that comment, and that's my feeling on it. So now I'll go to Bok. I know I'm getting ahead, but I didn't understand why George asked for the 2 comments be removed from the clip of Wendi calling Donna, but then turned around and asked the witness about one of them. Here's the only explanation I could get. Georgia's in trial mode, and she's like, hearsay, object to hearsay. I'm going to win this objection, winning it, strike it. Okay, cut that. And she kind of already had her cross prepped, and she went up and asked. So it's kind of like she compartmentalized. Argue this piece of evidence, keep out what I know is hearsay and can win that argument. Go ask the questions I want to ask. And she just kind of kept them separate and didn't do it on purpose. That's the only thing I can think of that may have happened. The defense did rest. Now the defense has rested. But again, if they come back in the morning, they can say, Judge, we want to reopen our case. And this has happened before where you're allowed to reopen your case. Like sometimes prosecutors are like, I thought this document came into evidence, but it actually didn't. Judge, can we reopen our case and put this document in? Okay, now let's hear some of these arguments.
Jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors. You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the 2 rights that the court has placed before you?
Yes, we discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision.
She says, I haven't. I'm not prepared to make that decision. Now, if she says the same exact thing in the morning, I think that's a fair argument you guys are making. At that point, it's over because the case is over and she had multiple times to sleep on it. The case is over. They've called every witness. There's no new evidence. There's nothing that can change because a lot of stuff happened today. More witnesses happened today. She says it. So now we're dealing with, is she making a knowing and voluntary and intelligent waiver, or is she being pressured to and forced to by the judge? Those arguments get made on appeals. I'm not saying it's a dead bang winner, and I would never want to take my chances with appeal. I'd much rather have a fair trial the first shot, because what's your prize if you win on appeal? Another trial.
This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping that we'd have some time to speak to my
This
attorneys.
has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine.
I will give you.
So he gives them 5 minutes, which we're going to skip ahead of those 5 minutes till we are back. And now we're going to hear what the resolution is. Nina said, can she call Harvey tonight and change her mind? Again, I answered this like potentially it'd be up to the judge. You could try. I'd let her if she came back in the morning and said, because there's no other witnesses, nothing has changed. The defense can just reopen, call her, then rest. And then again, if the state wants to call rebuttal witnesses or whatever, I get it that stuff happens, but this is most important, my opinion. But generally she shouldn't. That's not how you should do it procedurally. That would be like an exception to the rule. Actually, before we get to this last clip, let me give you the update on the conspiracy. 94% say guilty on conspiracy to commit M. 6% say not guilty. All right, Kelsey, let's put up the last one, which is solicitation to commit M. And that will be the last poll that we vote on. So we're at 87% or 83%, 94%. So overwhelmingly, the chat is in favor of a guilty verdict here, or thinks it's gonna be guilty. One Kelly said, I'm 66, stop calling us elderly. In our mind, we're 35. I always try to be careful about that, okay? But like, honestly speaking, when I have clients that are of a certain age, it can be, I'll tell you this, it can be them asking me or them needing more time, and we're finding arguments to make the judge, and that's one that sometimes works. That's all I meant by that. I feel bad for Charlie. He should have listened to Rob. I don't know. I don't know what that's in reference to. All right, let's hear the end of this argument.
We are not finished with the colloquy quite yet.
By the way, it sounds like I can't see the lawyers and Donna, but it seems like they're still talking. He is not happy. He's like, 5 minutes. I'm going to be right back here. And then he threatens contempt if they keep talking to their client about this decision. I honestly am like, I don't know if Michael Ufferman's going to be her lawyer, right? Because he's Charlie's lawyer. But I think he's one of the best criminal defense lawyers in the state. I think her appellate lawyer, I meant one of the best appellate criminal lawyers in the state. Her appellate lawyer, this is going to be a key moment for her appeal.
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains. As it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
Very well.
At this time, I don't want to testify. A lot of talk about elderly in the chat. I don't know what other words I can use, but they're in the law, legally speaking. If you commit certain acts against people over a certain age, that's how the law is written. Okay. And that's what I was focusing on. All right. All right. Everybody, come on. Come on. I love everybody of all ages.
As I previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Did say that, Judge. May I have a moment to confer with the counsel?
Go ahead.
So now they're talking about whether or not they're going to have a rebuttal case. I think that's the end of what we needed. If you guys have not hit the like button yet, please take a second and hit it. So basically, that is the entire defense. They're going to rest their case in front of the jury now, and that's it. They called witnesses to talk about how the family law case was not contentious, basically. I'm going to do this quick because we don't have a ton of time. Here's basically their whole defense. Ann Cunningham, Donna's a really great person. I'm her best friend. Definitely seem biased towards Donna Adelson as her best friend. Really good cross on her as well. Then Rob Gutterson, her life partner again. Friends with the Adelson. They're great people. Normal Jewish grandparents. Well, what about the stuff they wrote in the family law case? Oh, well, we don't know about that. Digital forensic expert. They didn't talk to each other as much as it may have seemed. 69 versus 80, whatever it may be. Richard Chagrin. I told them to save a few bucks and do the one-way ticket. So again, fighting Vietnam. The two other friends also fought her fleeing for Vietnam. And then they had the two private investigators to try and cut the credibility of the jailhouse snitches, which I thought they already did a pretty good job of on cross, but that's what they focused on. Then Detective Turner to say, look, Donna and the jailhouse witness were both writing in this notebook after they already consented that it is Donna's writing in that notebook. And then today we get to the family law case was not that contentious, basically. That's basically their entire defense. I don't think it did much, personally. I don't think it did much. But I don't know. I mean, if I was going to have a lean here, I'm leaning towards a quick guilty verdict. If they do 2 hours for each side on closings and jury instructions tomorrow, I think it's a verdict Friday before they go to the weekend. I think there's a verdict. I'm going to be driving up to Tallahassee tomorrow night-ish, so I'm not going to be able to see closings. I will do a video when I get to my condo in Tallahassee, and maybe I'll be able to get to the courtroom for the verdict. I bet it'll probably be packed, and I might not be able to get a seat, but that would be interesting. Sorry, I didn't mean to put that one up. Janet, finding someone facing life in prison with a contempt charge is laughable. Yeah, but also the lawyers, right? The lawyers don't want to be held in contempt. So I think that was probably the people that were more scared of it. Valerie said, Bill Reed just said your name in his interview. What interview? Bill Reed is a king, man. That dude has been through it. You can feel it when he talks. I'm a dad of a daughter. And if my daughter had to go through that, I mean, it's so tough to think about what her parents have been through. And he is a really great interviewee. Like every interview I watch of him, I'm like, man, I feel it. I feel with that. I can understand why they wanted to potentially call him in the case. I don't know if there will be a verdict tomorrow. Like if they get the case at like 3 or 4 o'clock, I don't know. All right. That's all we got, folks. Until next time, we're out of here. Sorry, this one was a lot longer than all the others, but hopefully you hit the like button and hopefully you're subscribed. Love you all. I'll be hanging out with you again tomorrow. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.